All right, welcome everybody. I'm attorney Justin Randall with Hooper Law Office, and today our topic is about what business planners, or excuse me, what business owners need to know about estate planning. There's a lot of things that, especially with estate planning, are a little different for business owners, or they just need to be a little more careful about thinking about, because there's more than just businesses are more than just an asset, right? You have employees potentially, you have maybe a family business that's been around for generations. So there's a lot that you need to plan for in advance if you're trying to pass that asset on, or if you're trying to plan for that business in the sense of maybe an exit strategy at some point too. And those vary a little bit, but it's also important to start thinking about hopefully 5 to 10 years before that ever comes up as a need for you. So in general, when we're talking about estate planning, you may be familiar with the concept of a will or a trust, or the types of things that you need to be aware of with those, meaning, wills go through probate, trusts do not go through probate. So those are sort of the very basic overview of a will and a trust. So you may understand, you have some concept of how those function or how those play into your plan. And you may very well have a will or a trust that you're working with for your estate plan right now. But you also want to make sure that your business also is planned around what your estate planning goals are. So, your beneficiaries of the business may be very different than the beneficiaries of your other assets. Maybe, especially with family businesses, not every child that you have may be involved in the business, right? So those are very important things to be aware of. Before I go too in depth, though, just a little piece of information here for you. So if you've signed up for this, you will be getting via email this types of business structure handout. It's a handy little chart about kind of the differences between sort of general overview types of business structures, sole proprietorships, partnerships, LLCs, corporations, those sorts of things, and like how they work with liability in particular. And how they're organized as entities. So it's a helpful little tool to refer back to, especially maybe if you're thinking about changing your business entity or starting a business. It can help you make the right decision for yourself, or at least come in with an understanding. And then another quick heads up is if you're participating on Zoom while this is live, you can actually ask me questions. So I do have a Q&A box right in front of me or off to my left, so I can see that come up if you have any questions, and I'll answer them as we go through things. Okay, so as I mentioned, one of the things with business planning that you really need to be aware of is what the estate plan is for that individual as well, or for yourself. Like I said, the end goal for those things can be different. They don't have to be the same. Maybe the beneficiary of the business or the person who is going to succeed you in the business is different than the person who would inherit from you, or the people that would inherit from you. But that still means you need to coordinate that with your estate planning to understand what that actually effect would be of when I pass away, what's going to happen, right? So in terms of ownership, that's probably the biggest thing that people think about what happens to the business when I pass away? Obviously, if you don't have any other sort of operating agreement in place, or a buy-sell agreement, right, where there's some sort of provisions for that type of planning in there, depending on how you own your business, if it's like a corporation, let's say, your shares in the stock of the corporation may be subject to the terms of your estate plan when you pass away. Well, if you have a person in the business who is more fit to take over and operate the business in the meantime, and you want to ensure that that's going to happen, it may not be the best thing in the world for your family to inherit those shares of stock. That's not to say they won't get the value of it from you, but you want to make sure that you're years and years in advance of ever passing away, or having a disability, for example, trying to plan with the person in your business who's your chosen successor. And that there may be some overlap between who that person is and your family, especially if it's a family-run business, right? But that's not always the case. For example, a really good example of this actually would be like attorneys. Our family members, if they are not attorneys, cannot own and operate a law firm. So when we own a business or own a law firm, we want to make sure that we're planning for the family to still be provided for potentially, and maybe get the value out of that person's ownership, but not actually have ownership in the business, because that could be a really big problem for a law firm. That's not necessarily the same for all sort of like medical firms either. I mean, Doctors, obviously, it's not, being a doctor is not a family business, right? But bigger companies tend to own like offices these days or hospitals. So that's maybe a little different. But lawyers in particular are a really good example of a profession where you have to be very careful about where those shares go or where that interest goes, because not everybody can own a law firm. I mean, it's within our own rules of owning a law firm through our rules of ethics and things like that, where we have to be very careful. So if your goal is for the value of the business to go to the family still, but you don't want the family to be able to control the business because maybe they just don't have the experience with it, or they don't have, maybe you've already have that chosen successor within the business, right? And there's already some sort of maybe verbal agreement in place about that. It's really important to get some sort of documentation in place about, okay, here's what has to happen if I pass away, or if there's an unexpected disability. So when we're talking about business planning or business succession and exit planning, we're really looking at it from two time frames, right? What happens if something unexpectedly happens in the meantime before the planned exit or the planned sale of the business, or nobody plans for their passing, I suppose, and of the exact date, but before someone passes away, what about that unexpected sort of sudden event where I can no longer operate or own my business? How do I make sure that the business continues on? How do I make sure that somebody can step in and deal with the contracts of the business or the prior obligations of the business? Who can act as an agent of the business if I need them to step in and meet payroll for the upcoming pay period, or make sure that they can deal with my vendors, right? I mean, those sorts of things are very important to have that chosen successor, appointed sort of agent that can step in for you if you do have an unexpected incapacity. So that's definitely one side of it. But then there's also the sort of, here's the actual plan of, we want somebody to, eventually I plan on retiring, or I plan on selling the business. Here's my chosen successor. Here's what that time frame looks like as well. And that is a much more intentional, drawn out process of making sure that certain things are met, certain financial obligations are in place, right? But both of those sides of that planning are very important, because if you don't plan for the unexpected, it doesn't matter what your very carefully crafted, here's my exit strategy or my succession plan for my business, doesn't matter what that's going to be if you don't also have contingencies in place for someone to step in and deal with the day-to-day operations of the business in the meantime, right? So when you're talking about what you need to know from an operational standpoint, and when it comes to like your estate plan and the operation of your business, it's really, really important to know how your business and the ownership of your business works with your estate plan. Is it controlled by your trust, or would it go through probate, or are there other buy-sell agreements in place that deal with my death and the ownership of my business? Do you have that chosen successor, right? Those are all very important things to know. But also you need to look at what documents does your business have in terms of governing documents or contractual agreements, those sorts of things. A lot of business owners aren't necessarily as protected as they would otherwise think they are from like liability, because they don't know what the governing documents of their business actually say, or maybe they don't have governing documents of their business. A very prime example of this, where we tend to see this the most, there's actually sort of two times you would maybe see this the most. Sole proprietorships, right? It's just me. I don't have an entity. It's just me doing the business. A lot of times sole proprietorships, I mean, there's not really they don't tend to have that governing document, right? I mean, they're just the individual, but maybe that's not the right fit for them, and they want to look at a business structure to provide a little bit of extra liability protection. Another really common type of entity I see that does not have a governing document or a custom one drafted would be like an LLC, for example. A lot of times people come in and talk to us about LLCs. They may have one already. And my first question is, do you have an operating agreement for that LLC? Or an operating agreement, if you're unfamiliar, is sort of like what corporate bylaws are, right? It's what are the rules of my business that I have to follow or any other owner has to follow in terms of the operation on a day-to-day basis, but also in terms of what happens if one of us unexpectedly passes, right? Who's in charge? So an operating agreement is that type of document for an LLC. But a lot of people will think they do have that, when in actuality, what they have is what's called the articles of organization, which is really what you get when you set up the LLC with the Wisconsin Department of Financial Institutions. So it's basically a one-page document that says, here's the name of the LLC, here's the registered agent, and some other kind of other information that you put in when you're setting it up, but it's not the governing document. So if that's all you have for your business, you still have rules that you're supposed to follow. A lot of times though, and I can guarantee most people have not read the Wisconsin statutes where those rules actually then are in effect. So if you don't have a custom governing document for yourself, you don't have an operating agreement that you've adopted for your business, for your LLC, I should say, you still have rules to follow through the Wisconsin statutes. And there's a lot of statutes in there that, or subsections in those statutes that basically say if you don't have an operating agreement or it doesn't otherwise state this type of thing in the operating agreement, here's what your rule is. Here's what you're supposed to follow. And why it's so important to know what those rules are and follow them is if you don't follow your own rules for your business, that liability protection that you may have because of that business entity may not be there for you in the capacity you think it is. One of the first things somebody will try to do if they're suing a business is try to what's called pierce the veil. If you've ever heard that term, you may know what I'm talking about. It's a very, basic law school type of term that was taught in very early, my 1L business class about how somebody will try to go through for liability protection, piercing that veil of protection, so to speak, so that they can come through to the individual owners for liability. So it's really important to know what those rules are and make sure you're following your obligations. What does the operating agreement require you to do? What is it, what happens in terms of a disability or a new owner buying on, all of those sorts of things. And that does play into your estate plan, because if you haven't been keeping up the liability protection for your business, it's really important for your family or anybody dealing with your estate to know, okay, well, what do we maybe have to be aware of if this wasn't being properly, kept up in terms of the liability protection. In terms of another sort of cross between liability protection and estate planning would be when you have business accounts, right? Assets of the business. How are those owned? A lot of times people with business entities, they don't ever actually set up a business account. They may have a personal bank account. This comes up a lot with LLCs in particular. They may have an account in their own name, and maybe it is a business account, but it's not in the name of the business. That can be really problematic in the event that that person passes away. Because if there's multiple owners of the business, or there's somebody who would need access to that account, should something happen to the owner of the business, like that registered or appointed agent to step in temporarily at least, if it's in the original owner's name only and not in the name of the business, if they pass away, it may be subject to the terms of their estate plan and be unavailable for the business to continue to use in the meantime until things get sorted out at least. But it may also just not be an asset of the business potentially, which could be a problem. But in terms of liability protection as well, if you have a business entity like an LLC or like a corporation or a partnership, right, or just a separate entity from yourself, you need to make sure that you are doing business and representing that you're doing business as that entity. If people can show that you've been paying for business expenses out of personal accounts or accounts that are just in your name, even if it is a business account, if you're not representing that distinction between yourself and the LLC or a partnership or corporation, right, that's another way that somebody may look to see through liability wise and potentially cause some issues for yourself if something happened with a debt of the business or a lawsuit for the business, right? So the most important thing for liability protection, especially when it comes to dealing with the estate planning side of it and making sure the business can continue on, is making sure that you know what your governing documents say, or if you don't have any governing documents that you've had made for yourself, look into doing that. And then also making sure that when you're doing business, that you are representing that you're doing business as the business and not confusing anybody that you are doing anything as an individual. So it's very common that this happens, which is why I'm stressing it, because a lot of times it may be a sole member LLC where somebody's, well, I am the business, but for a legal standpoint, you really need to make sure you're showing that separation. So making sure your assets are titled, and the business assets, I should say, are titled properly with the name of the business, or if it's using any personal assets, making sure that there's some sort of documentation between yourself and the business that it is, maybe leasing land from you, or, something like that, some connection that's saying, it does not own these assets. It is still separate, but I have the documentations in place. In terms of continued operation of the business too, I mentioned like contracts and obligations. From a more practical standpoint, less so a legal side of things, but it obviously still ties into it, would be making sure that you do have an appointed person, at least, who can temporarily operate the business in your absence. A very interesting concept, and this may not work for every business, but talking with some professionals who work on transitioning law firms, one thing that somebody did in the past was they stopped going to their, they took time off and to see if the business would continue to operate without them there. Was it ready for that transition? Was it a self-sufficient business, or were they too heavily involved with it, where if something happened to them, the business wouldn't continue to function, right? And eventually they found that it was self-sufficient. And so that's the kind of thing you want to set your business up for, though. You want to make sure that if you do take that vacation, or maybe it's not a vacation, but an unexpected health incident where you can't work anymore, or you do pass away, make sure the business is self-sufficient as much as possible. And that involves having that chosen person. Maybe they don't end up owning the business, but they're the manager, at least, for somebody who can continue to do the day-to-day things. Making sure that they know what sorts of bill obligations are in place for the business. Do they have a certain vendor that you use? Are there contracts in place about that? Those expenses. What do they have to do if they need to give out paychecks? How is that all set up? Those are very important for that person to know, whether it's a family member who's that chosen successor or not, to know what they need to do. Because if it doesn't matter how, from the legal standpoint, you set these things up, if you don't have that practical side of it taken care of as well. I mean, you could have the best LLC documents in the world, the most expansive buy-sell agreement with all the best legalese in it. It won't make a difference if there isn't that person who can continue the business from a practical standpoint and from an experience standpoint. So it's hard to plan for the succession or exit of a business from a business. Succession more so if you don't have that person, right? The person who is fit to take over for you, or that chosen successor. And it's not an easy thing to pick, right? I mean, this is obviously a very important thing to be aware of in advance, so you have that time to do so. So once that chosen successor is in place, though, that's where I was talking about. You probably want a 5 to 10 year period of time where you sort of train the person in how to run the business, and you train them in what they need to know in that day-to-day operation, and make sure that they are actually the right fit. With contracts and obligations of the business, it is very important to have these in writing. It's very common for business owners to have sort of verbal agreements, especially smaller businesses. Verbal agreements, kind of the handshake deals, right? Where, hey, this was our agreement. And maybe you'll honor that with somebody and they'd honor it with you, but your successor may not know the details of those agreements, or may not be bound by those same agreements if they're not in writing with the business. So if you have some sort of deal in place with somebody for a vendor, or for like a buy-sell agreement for buying that business, it's very important that you actually put it in writing and have it properly signed, notarized, things like that, so that it's very clear what's in place there. Without those documents in place, it becomes a bit uncertain what may happen. And this is becoming less common. I think there are more and more people who are starting to put these things in writing as sort of a practice, but especially the older businesses that you would see kind of, they were sort of small towns. They kind of all got along. They agreed. It was, on the honor system, right? That was where you would see some problems come in, where the next generation may not be may not know what those deals are, quite frankly, but may also feel that they want to renegotiate those deals. And that can create some problems if there's not something in writing to enforce it. Verbal contracts can be enforced, but it's very difficult to prove that that actually existed in comparison to when it's clearly in writing. So just be aware of that. If you're already doing that, then I don't need to harp on you too much. It's just it's very important, and that everything is in writing. In terms of your keeping up your business plan and making sure that this is working, with estate planning, we say, for example, that we really want somebody to have their documents or their plan reviewed every 5 years or so, 3 to 5 years. It's kind of a good ballpark, and that's definitely the same for businesses as well, especially if you have a succession plan going on, because you need to make sure that, okay, let's do this kind of checkup on the situation. Is it still working for you? Is there anything we need to change? Is that person you picked as a successor still the right pick, or has something changed there, right? Do we need to be aware of it? So just like in estate planning, where things may change in your personal life or legally that you need to update in your documents, that's the exact same thing with a business plan, and making sure that both of those documents, both of those plans are kept up to date with any legal changes that come up, but in particular with your life changes. Legal changes, things like that. Those are the sorts of things that we give notice to people when big changes happen. We have to, so that they're aware of it, especially if it impacts them. But the lifestyle changes, things like that, your attorney may not be aware of those things, and they may have no way of being aware of those things unless you tell them. So that's why, whether it's your business planning documents or estate planning documents, but both actually is what you'd want. You want those reviewed every 3 to 5 years. I see a lot of operating agreements, a lot of bylaws for corporations that were maybe done in the early 2000s, the late 90s, right? And you just don't know what laws have changed if you're not keeping up to date on it. And quite frankly, as a business owner, you're busy enough that's why you have attorneys to do that for you, right? It's the same reason I don't do my own taxes, right? We have CPAs who help us out with that. You're busy, and that is why you have that attorney to go to, that business law attorney and estate planning attorney, to help you make sure that those documents are up to date. It's my job to stay up to date on those laws. Your job is to operate your business, and that's why it's very, it's not expected for you to know when those things change. So coming in and talking to an attorney is very important when you've had your plan drafted. As far as an exit plan from a business and your estate plan, exit planning, by the way, meaning more like you're just looking to sell. It doesn't matter what happens to the business afterwards. Maybe the business will cease to exist. Maybe it'll be just completely sort of reorganized by the purchasing entity or person, right? But you're not succeeding or being succeeded by an individual with the current business. That's also still very important with your estate plan, though, because if something happens in the meantime, you want to make sure that you have someone in place who can continue those negotiations, or at least continue fulfilling that exit from the business for your shares and your ownership. So succession tends to be more of our focus when we're talking about the estate planning side and sort of the unforeseen circumstances, because you're generally not planning to exit a business when something unforeseen happens. Usually it's more of you were still just continuing to operate the business, or you were looking to eventually succeed or be succeeded by somebody, but just not maybe in the near future. But either way, when you're talking about appointing someone to be your representative of the business, you want to know, does your operating agreement or your governing document, does it appoint an agent below you, like an officer of the company, something like that? Think like CEO or president, right? Vice president, that kind of thing. Do you have somebody below you that can be that person? Do you do you have other documents, sort of like a separate document appointing that representative temporarily if that happens? What do those documents say? That's always going to be your first step in understanding what those documents actually do and say in those circumstances, of what you may need to change if that's not your intent. That's always the danger of using the sort of statutes that are provided through Wisconsin statutes about, like, here's what happens if you don't have an operating agreement. A lot of times they don't actually meet what maybe you yourself would anticipate or want in that circumstance, right? It's the same thing when somebody passes away without a will or a trust, right? The default provisions in Wisconsin law may or may not meet your goals. So knowing what that is very important, and that'll help you get started. How you know what is in there is I don't expect you to go out and read the statutes right now, but you need to talk to somebody who practices in these areas if you're unfamiliar with unfamiliar with the law yourself. And there's absolutely nothing wrong with that. Like I said, you're very busy and not expected to be the ones who stay on top of those things. So I'm running close on time here, but I just want to close off with a couple different things. Just another reminder that you'll get this form, sort of the business structure form chart, from us. You'll also receive a form about a feedback form where you can put on any feedback that you have or topics that you may be interested in hearing about. But it also does give you a place to set up an initial consultation with our office. We offer a complimentary initial consultations. We schedule them for roughly 2 hours or so to give us enough time to go through things. So complimentary, again, you're not paying us to come in and talk to us. We'll be able to let you know kind of what cost or fees would be usually by the end of that initial meeting, but maybe it'll take a couple depending on the complexity of the situation. So don't worry about, it costing you anything to come in and at least talk to us initially. When it comes to the information we're looking for, if you have business documents that you currently have that are maybe older, or you don't have anything at all, those sorts of things are good to know for that meeting. So if you're interested in that, or anything I raised today is raised any concerns for you about your business or your estate plan, it's definitely a good use of time. And then our topic for next week is actually same time every week on Wednesdays, is what to do if you have a loved one who may need care soon. So care referring to like long-term care, assisted living, skilled nursing, those sorts of things. There's a lot of really good information that we're going to talk about there about what you need to be aware of and what you need to do to plan for those situations, especially if it's maybe coming up faster than somebody expected. I don't see any questions. So with that, I will let you guys go and enjoy the rest of your day. But thank you for joining me, and I hope to see you guys next week.